Okay, so those of you who are, for the first time attending this lecture, let me give you a very brief thing, right? That I take one and two topic and I discuss, that what has to be studied in that particular topic, right? And also I give one question, right? And I pick up one or two of the questions and I try to answer you. I mean, whenever you will submit the copy, I will try to check it, okay? So that is how, this whole program functions, okay? Now, I have already completed the whole constitutional law, that is your part A of the syllabus. Today, I will be starting from part B of the syllabus, right? And one more announcement I have to make actually is that now I will be, I have been, I have already told you my test series batch have started, right? So I have to give almost 2-3 hours daily on that. Similarly, I have this, this foundation batch also. So they are also 2-3 hour goes, right? So nowadays I'm having almost 5 to 6 hour classes, right? It becomes very hectic for taking this class each day. So what I will be doing, right? Some of you also have suggested the same thing, that I will be taking this class on Tuesday and Thursday, only 2 days a week. Now, see, the purpose remains same. When I explain you two topic, at least you will require 2 to 3 days to self-study it. That everyone, I suppose, is agree. Okay, is agreed that at least you will require 2 to 3 days to study it, right? So why not give a gap of 2-3 days between two lectures, right? So that is how this whole lecture I will try to, I will try to teach, right? I will finish the whole syllabus because for constitutional law I took around 11 class, right? So part B around, it is a shorter version, so I think it will be finished in 6 to 7 classes, okay? And thereafter, 15-20 class will be needed for paper two, okay? So that will be the structure, okay? Nowadays, please, keep that in mind. That modification have been done, okay? And that sometime is going to help you also in that sense that sometime it is very tough for me actually to come up. See, when I was मैं खाली था तब तक तो मैं obviously I could do it daily, but all the batches have started, right? So really it is a very big burden on me, right? So I'm trying to lessen the burden on myself, right? So I apologize for if you think that I'm going back on my promise, right? I apologize for that. And this GS paper too, I will be discontinuing, in totality, because again that becomes quite hectic, right? 1 hour daily, right? So that is really very hectic for me right now, right? And other batches have also started. I thought that de facto IS will start everything after some time, right? But they have started right now itself, okay? Because बात भी सही है कब तक लॉकडाउन चले, right? 2 months हो गया, 3 months भी होने जा रहा, right? So that is why this is really a problem. It is really a problem. Okay, चलिए. So let us start with the today's lecture, right? See, today I will be discussing around two topics, right? And both of those topics are basically related to international law, right? If you look at these two topics, you will find that the first topic says nature and definition of international law. Right? You can always expect one question from this. Okay. Yes, I will be not continuing with GS2 at all, right? So it becomes really very hectic. Later on, I will see if I have time, I will complete it. Okay, Mister ABCD, whatever your name is. Okay. Second is the relationship between international law and municipal law. That is the second point, right? Relationship between international law and municipal law. That is the topic 2. Okay. Now let us go into detail about these topics, right? And let us try to understand that what exactly we have to study in these topics or what kind of question comes. Okay. See, first when we talk about nature and definition of international law, then one thing is that is almost you have to practically mug it up. That is your jurist definition, right? And the most important jurist definition is basically, if you remember, Oppenheim. Okay, so Oppenheim definition has to be studied. Its criticism has to be studied, and later on, Oppenheim came up with new definition, right? So what was the problem in the old definition, right? The most important problem was basically it was related to the law, the international law they have defined as a law between a civilized nation. Now the concept is that what is the meaning of the word civilized? Because the word civilized is very generic in nature, right? How it is very generic in nature? Because the Western world think that they are the only one which is civilized and rest everyone is uncivilized. Okay, so in that respect, the meaning of civilized was criticized. Understood that particular point? Okay. Similarly, there are multiple other jurists as well. Okay. Now remember that you have to cite whenever there is a question with regard to definition of international law. You have to cite the the jurist definition verbatim. Okay. So it means you have to practically memorize it. Do not try to apply your own brain and write your own definition. You are not a jurist. Okay. That one thing I keep telling all the students, that you are not a jurist, right? So in law optional examination, when you write your answer, do not think that you will be writing such a sophisticated line, such a sophisticated vocabulary. You won't, it is practically impossible for you to do it, right? So you have to study, you have to practically verbatim quote it. At least the keywords should be quoted. Even if not verbatim, at least the keywords should be quoted. Okay. So try to remember the juris definition. And this also I have given some of the juris definition, obviously. Then we will come to the second subtopic, and that is basically meaning of new international law. Now there have been a question that what is the meaning of old and new international law, right? See, new international law basically comprises the judicial decisions. Okay, so judicial decisions were not part of the old international law, right? So it is a part of new international law. Okay, so that is the various development related to judicial decisions that you can think of, right? Like for example, there are certain judicial principles which have been accepted all over the world. Okay, like this res judicata. Now, this res judicata is accepted in our common law countries like India. It is nowadays accepted in civil law countries in Europe as well, right? So even if it is not a part of international law, it is a part of new international law. Okay, so there are certain principles which have developed to become the part of new international law, right? So those principles has to be studied, those principles has to be understood that particular point. Okay, so that is the meaning of new international law and the latest development along with it, right? One example that I gave is res judicata, right? So res judicata, similarly PILs, right? So PILs also has become, right? PIL is basically what, giving an individual authority in international personality. I mean, giving an individual international personality. Okay, so that is again a new development in international law, right? So that is also sometimes referred as new international law. Understood that particular point? Okay, so the new international law has to be understood in terms of its recent development. Done? Good. Now let us come to the third, that is the nature of international law. Now every time there is a question, this year also there was a question, and these questions are repeated every time. Every time it is repeated. There is no difference at all. If you look at last 10-year paper and the nature of international law, the question has remained same. Three things. Is it a positive morality? Vanishing points of jurisprudence and weak law. बस तीन चीजें पढ़नी है. Is it a positive morality? लिख भी लीजिए, अगर नहीं है तो write it down. ये मैंने लिख भी दिया है actually. See here itself. Weak law, vanishing point of jurisprudence, and positive morality. ये भी लिख लीजिए इसमें. It is a positive morality, nothing more than that. Okay. Now prepare a ready-made answer for these three questions. Right? Is it a positive morality? Is it a vanishing point of jurisprudence, or is it a weak law? Right? Now, with regard to positive morality, it is basically Austin's view, right? So, Austin's view in the case of law also, it is quite relevant, okay? So, the same argument of the Austin will apply here, that there is no sovereign, and as the law is a command of sovereign, right? So, absence of sovereigns makes it a weak law, right? Now, if you talk about the argument against it, then the argument in support of Austin's view are that if there is a sanction, then only a law becomes a proper law, right? So without sanction, the law will never become a proper law. Now the question is that how to obtain that sanction. Right? So in international law, there is absence of sanction. Now, opposite argument that you can make is that, see, even if there are sanctions, certain laws are not followed. So sanctions becomes irrelevant in determining the weakness of any law. Why? Right? Murder के लिए तो बहुत सारे sanctions है, but still murder takes place. So can we say that the law related to murder in India is a weak law? No, obviously not, right? So the sanctions is immaterial in determining the nature of law. Okay, so that is the point where you can criticize the Austin's view, right? Now, when we say it is vanishing point of jurisprudence, it simply means that the traditional definition of jurisprudence or the law or any other thing related to it, right, do not fit in international law, right? So that is the meaning of vanishing point of jurisprudence. Okay, it means that when we talk about classical jurisprudence or the modern jurisprudence, that do not exist in international law, that is incapable with their application in respect of international law, like the concept of property, right? So if you simply see the concept of property as well, it is very tough to determine, that which part of property, what definition of property shall apply in international law, right? Like for an example, in the case of property, the most important thing is basically determination where the property exists, right? On the basis of that, the jurisdiction and everything applies, right? In re propertia, in the case of property, you must have seen this, Latin concept, right? Now the question is, how do you determine where the property lies, especially in the case of international, organizations, right? Now that is something very, interesting thing to understand, that cannot be done in international law, right? So that is the meaning when we say that it is a vanishing point of jurisprudence. This year also there was a question with respect to that, right? तो इस तीनों का moral आंसर तैयार कर लीजिए. Vanishing point, positive morality, and weak law. Take an argument for, argument against, along with some jurist opinion. That will be sufficient for that. Okay. No need to study the history of international law, not at all. ठीक है ना, सवाल कभी नहीं आता. Then what are the different bases of international law, right? Now if you look at the different theories of international law, right? So there are positivist theory, right? There are realist theory. Okay, so there are multiple theories related to it. Now you should read those theories in basically very short. Okay, very short analysis, because directly the question do not comes, but these are important when you argue a particular, a particular question in international law related to philosophical aspect like weak law, strong law, right? So the positivist and realist theory, two theory at least you study. There are obviously multiple neo-realist theory, neo-positivist theory, but only study positivist and realist theories, right? So that will be more than sufficient. Okay. Now, which of the following is the most suitable one, right? So I personally believe that it is the realist theory which is the most suitable one in international, right? See, in international relation also, there are two theories, right? The one is referred as realist, other is referred as liberalist. See, in the case of realist theory, international relation also, what we assume is that every world countries are basically trying to kill each other, right? So what they try to do, they try to harness so much power that they will be safe. They try to harness the power so that they will be safe, right? Now, once they try to harness more and more power, automatically it creates, a deficit in power with respect to another country. So other country also starts to feel like that, okay, I can be subjugated, right? So they try to create that balance of power. It means in realize the countries are assumed to be an independent, homogenic entity. They are interacting with each other at diplomatic level, nothing else. But liberalist views are that no, any international law is a result to not government to government relationship as a homogenic, but it is a relationship which exists at different layer in those particular countries. It means there can be cultural relationship, there can be economic relationship, there can be social relationship. Okay, so it means that two countries are not monolithic substance that are basically interacting with each other, but two countries are basically set of different groups of people who are interacting with each other, right? They are set of different groups of people who are interacting with each other. Understood, right? So the liberalist views are, that international law governs those set of relationships. The realist view are that no, international law is basically governing two sovereign, nothing else. So right? So when you support realist view, you say that international law is a weak law, right? But when you support this liberalist view, you say that international is not a weak but it is strong law. So हमारी बात तो वही मैं कह रहा था, two theories actually you study. Okay, that will be more than sufficient. You need not to study any more theory. Then we will come to the second topic. See here. Now remember, basis of international law is not there in our syllabus, but still the question have been there. Okay, so you have to study the basis even if it is not given in the syllabus. Okay, that point remember. Now, again, one thing which is not given in topic, but is still directly not provided in the topic, but still the question comes is the source of international law. If you look at the law option syllabus, nowhere the word source is mentioned. Nowhere, right? But still there have been question on source, right? So that is covered under the nature and definition itself. Okay, that is the source of international law, right? Now you must be knowing Article 38 ICJ, right? And it provides that there are four sources, right? See here. About each sources now, especially focus on custom as a source of law, international law. Now this custom, lot of time a question comes, see, basically there are three words, remember, habit, usage and custom. Habit leads to usage, usage leads to custom, right? So there have been a question that habit crystallizes into custom comment. Okay, that is very correct. Habit crystallizes into usage and usage crystallizes into custom. Okay, now you have to go into the nitty gritty of the meaning of custom, right? Along with the case laws, right? You must be knowing not see continental self case, the most important case, right? That is the most important case that you have to study, right? Now, When you talk about custom as a source of international law, then you have to also read that how this international laws, how this custom as a source of international law have done till date. Have all the custom been statutified? It means everything have been written in a statute of international law, or is the custom still existing? Okay, now what happens if there is a conflict between custom and a treaty, or there is a conflict between a custom and judicial decisions? Okay, or if there is a conflict between bilateral and multilateral customs? Okay, so you have to go into the nitty gritty of the word custom, and you have to study that in very very detail. So हमारी बात ये point clear है, understood, right? So the custom is an important concept to be understood, because in the source of international law, most of the question actually comes from the customs. ठीक है, तो ये 3 वर्ड लिख लीजिए, अगर याद ना हो आपको तो लिखिए. That is your habit, uses, custom, right? So habit crystallizes into custom. ठीक है, हैबिट को बिहेवियर भी कह सकते हैं हम लोग, बिहेवियर, लीनियर बिहेवियर, बिहेवियर, यूसेज एंड कस्टम. So हमारी बात की, right? So you have to write the different component of custom. You have to write different aspect of the custom. Okay. The books वगैरह मैंने पहले ही लेक्चर में बताया था, मिस्टर अभिषेक. If you are new, I will suggest you go to the YouTube and see the first lecture. Okay, I have talked about books in detail. Okay, Mr. Abhishek. Now, the next subtopic that is again not given in our topic is basically subject of international. Okay, now the subject of international law, a very interesting thing is that they simply ask that how an individual is a subject of international law. Now, if you have studied international law, you must have seen that there are two types of private and public international law. Normally, the law is also of two types: private law and public law. Public law governs the relationship between the state organs, and private law governs the relationship between citizens. Right? IPC is a public law, private law, administrative law, constitutional law, international law is a public. Right? So that is the difference between public and private. Right? So in the case of international law, also we have a public law and private law. Right? So when we have a public law, basically it is governing institutions. Right? But when we have a private law, it is basically governing individuals. Right? So there are basically two sources, private and public. Okay? If you want to crux it down, so it can crux it down in two sources. We have a private law, we have a public law. So right? So you have to study individual as a subject, okay, and institution as a subject in international. Then, so that is one thing again that is not given in our syllabus, but still the question comes. ठीक है, इसलिए मैंने कहता हूँ international law, the syllabus is short, but you have to study each and every topic of international. Okay, even if it is not mentioned in syllabus, because the question actually comes from it. समझ में आ रही बात? तो इस नेचर एंड डेफिनेशन में क्या क्या नई चीजों ने जोड़ दी? सोर्स, सब्जेक्ट. नेचर इज ऑलरेडी देयर, वो हम लोगों ने देखा. ठीक है, और सॉरी थ्योरीज, बेसिस. राइट, तो देखा जाए तो रियल सब्जेक्ट, मतलब आपका सब टॉपिक यहाँ ये होना चाहिए: नेचर कॉमा सोर्स कॉमा सब्जेक्ट कॉमा बेसिस एंड डेफिनेशन ऑफ इंटरनेशनल. ठीक है, सो दैट इज द हिडन सब दैट यू हैव टू स्टडी. Okay, so even if it's not provided, you have to focus on these 3 extra topics as well, because there have been questions. Custom पे तो clearly question आता है एक सारा. सब नारी बात की clear है everyone? Yes. Okay. Now let us go to the second topic, that is basically relationship between international law and municipal law. Now, if you look at the relationship between these two, right, then there are 3 basic theories, right? The one is the monistic, dualistic, and a specific transformation theory. Okay, now you have to go into detail about each of these theory. Now, to sum up in a very brief one point, I can say that the monistic theory basically suggests that international law and municipal law is part of same one law, because ultimately the law are for the purpose of governing people. The law are made for the purpose of governing people. So even if it is people of 2 countries or the people of 1 country itself, right, that makes no difference. Right, so that is the monistic theory. Dualistic theories, both are different. A specific transformation theory, that see, initially actually it is the municipal law which is being made, but when the people or different municipality or different countries started to interact with each other, the same municipal law basically transformed itself into international. Right? So that is the specific transformation theory, and that is makes sense as well, right? Like for an example, the example just I gave you, this res judicata. What is the res judicata? Every country wants that litigation should be stopped, right? So they apply this principle that once something has been judicially determined, that need not to be reopened. Okay, so that is something which is is a basis almost, or is one of the concepts that have been introduced in every legal jurisdiction. Okay, so that has become an international law. ठीक है, समझ में आ रही बात ये, ठीक है. So that is the meaning of a specific transformation theory. ठीक है, that is the meaning of a specific transformation theory. Understood that particular point? Okay. Yes, Akanksha is saying municipal law is a country. Yes, obviously. See, if you're a law optional student, I am assuming that you know it. Okay. So if I am wrong, the assumption is wrong, then I will suggest that you start from the zero. Okay. But while discussing these topics, I have assumed that you are a law graduate and you will be knowing these things. Now, if you are not a law graduate, I don't think this lecture is going to help you much, right? But most of you are law graduate, I suppose. Right? Most of you are. Okay. Now, not only you have to study these theory, but you have to study its pros and cons. Sometimes they ask you to criticize monistic theory. Sometimes they ask you to criticize dualistic theory. Now, in concept, it seems to be quite easy, right? But when you have to write, almost 250 words or 2 pages with respect to these theories, right? Then the word becomes, very scant. फिर आप एक ही words को बार बार repeat करना start करता है. तो यहीं पे you have to actually study in the book and you have to practically pinpoint the keywords. Even if the concept remains same, the line has to be different. Right? The line has to be different. So that particular point you have to keep in mind. And that can only happen if you read books and make notes with regard to it. समझ में आ रही बात ये आपको? Clear है? Understood? Okay? So please remember that. Now, the last subtopic is what courts in India follow according to this doctrine, what the courts in India follow. Right? Now, meaning that suppose, if there is international law and there is a Indian statute, what India will follow? Monistic or dualistic? Or if there is a inflict between, you write that down, statute and treaty conflict में इंडिया का क्या position है? Then treaty and custom में अगर conflict है तो इंडिया का क्या position है? If there is no conflict तब इंडिया का क्या position? ठीक है, तो अगर ये तीन चीज और इसके comparative study with respect to US and respect to UK, ठीक है, इस पे भी सवाल आता है. ठीक है, like for an example, in the case of treaty, India follows the concept that if the treaty provision is specifically violating the Indian statute will prevail. But the court will try to first harmoniously interpret between them. Clear? Now, if there is absence of any law and still the India is a signatory to a particular treaty, then that treaty will be adopted in judicial decisions. Now, if India is a party to a particular treaty and there is no specific statute with respect to that in India or custom with respect to that in India, right? Then only that treaty will have a value of basically persuasive, right? It means it can persuade the courts to take a particular viewpoint, right? Nothing more than that. So, especially in the case of resolution, non-binding nature of treaty, especially in the case of resolution, especially in the case of resolution. Now, what the point you missed? Sivangi, no problem. You wait. When I will ask questions, you raise your hand and I will kill you. Okay. Right. So that is one thing that you have to keep in mind, right? That what is the India's position with respect to treaty and normal law, between treaty and custom, if there is only law and no treaty, right? Okay, both of you wait. You ask me question again when I will give you the chance to ask questions. Okay, not to, right? So as you can see, at least 3 to 4 days will be needed to study these. Okay, right? So please study that in detail. Okay. Take any standard textbook, right? I generally, have this Stark. Stark is a good textbook, right? But you can take any SK Kapoor or whatever you have. That is okay. But be limited, okay? Do not start reading the whole. Not required. Okay. Now let us see some of the concepts, right? Some of the case laws actually, not case law actually. Mostly the concept I have given here. See the definitions. I've given the definition of Bradley. Torsen Gehi is a very famous Japanese international lawyer. A case in which the court says that the law of nation is a collection of uses which civilized states have agreed to observe in their dealing with one another. See here, you uses. Now, if there is a question with relation to custom, you can say that the British courts have defined international law in light of custom and uses. That is it. Then this definition should be cited. Right? So if you remember 5, 6 definition, then what type of question you are answering, that definition of that jurist has to be cited. सर हमारी बात वैसा नहीं कि एक jurist याद कर लिए खत्म हो गया. Custom आंसर कर रहे हैं तो ये jurist का ये definition उसमें होना चाहिए. ठीक है. अगर if you are answering suppose individuals, the individual nature of or the realist nature of the international law, certain other definition is required. ठीक है. If you are trying to answer a question which talks about that international law is a weak law, some different definition is required. Okay. So I have given here 1, 2, 3, 4 and 5 definitions. Okay. I've given you 5 definition, right? So try to जैसे ये देखिए, international law may be describe the sum of rules accepted by civilized states determining their conduct towards each other and towards each other's subject. Right. So when you have to talk about the individual or the realist nature of international law, this definition can be cited. Okay, yeah, individual as a subject of international law, if there is a question, this definition can be cited. समझ में आ रही बात ही understood? Okay. Malcolm Soy is also a good book. That is not. मैंने कहा भी कोई भी standard text book देखिए किताब कोई खराब नहीं होती. ठीक है. The only thing that you have to understand that you have to pinpoint that what has to be studied and what has to be left, and that is the pinpoint actually is. समझ में आ रही बात? No book is bad actually. Right? Remember. Okay. Now let us see the source of international law. Very typical. Article 38. Now, if you look at Article 38. 2 clauses, right? I've already told you that there are 4 important sources of international law. Okay. Now these sources are, remember, is in basically pecking order. It means that first this will prevail, thereafter this will prevail, this and then this. Now what are these sources? You must have studied conventions. It means it is talking about treaties. Custom, okay? Custom is a source of international law. General principle of law recognized by civilized nation. It means the judicial principle recognized in both the countries, right? Like Rest Data. And subject to provision of Article 59, judicial decisions and teachings of most highly qualified publicists of various nations. It means that the jurists, they come up with, suppose, a particular point of view that can also be used as a basis of international law, right? And after that, the scope have been left that the international law can be developed. Now, what is that scope? The provision of consideration of fair dealing and good faith. Okay? Ex equo et bono. Now, this particular line is saying that, see, if two countries trying to agree something which is against their treaty, दो country के बीच treaty है, but still they want to agree to something else, so they should be allowed. Now, that is one thing you can cite that international law is a weak law. It means that their very basis can be changed by two sovereign nations, which is not applicable in the case of municipal law. Understood that particular point? Okay. So this actually makes the whole international law, down under the river. That okay, even if we have a treaty, we can agree to something else and we can throw away the treaty. So understood? Okay. Now, if someone is expecting a particular set of behavior from a sovereign nation based on that particular treaty, can he be sure? Obviously, the answer is no. Right? So, if the treaty provision itself is totally up to the will of sovereign state, then obviously the treaty also is not a is a fixed document. It means it can also be changed. Right? Okay. So that makes this international law is a weak law. Okay, or more of a positive morality. Okay, so this can be cited actually. Then what are the other sources? The fifth source is the determination of the organs of international institutions. Okay, WTO decisions, right? Security Council resolutions, right? So that is again a modern development of international law. In fact, nowadays Security Council resolutions are the most important source of international law. Okay, in fact, it overrides the structure of the Security Council is such that it overrides almost a specific provision of international law. Okay, so that is again a very interesting thing. Then other than that, the state paper guidance of their officers, right? So if there is a state paper, it means judicial paper with respect to a particular state or a policy document with respect to a particular state, that can be taken as evidence of the custom. ठीक है, जैसे मिनिस्टर में जाके कुछ कह दिया, ठीक है, और एक पॉलिसी डॉक्यूमेंट मिनिस्ट्री ऑफ फॉरेन अफेयर ने इशू किया with respect to a particular trading routes or with respect to a particular disputes, right? So then that can be said that is a part of international law with respect to your country. तो जो डॉक्ट्रिन ऑफ अपोजिबिलिटी, ठीक है ना, इसको एक बार देख लीजिएगा, मैं इसको पढ़ा नहीं रहा हूँ, डॉक्ट्रिन ऑफ अपोजिबिलिटी इन रिस्पेक्ट टू दैट, ठीक है ना, इसको एक बार देख लेंगे, डॉक्ट्रिन ऑफ अपोजिबिलिटी. Okay, now in the case of India, there was a very interesting case, Portuguese versus India. In that, India basically won, and ultimately the Portuguese has to withdraw from Goa. Right? What was the crux of the case? The crux of the case was basically, it is not written here. Let me tell you. Basically, Maratha, from the Maratha, the sovereignty went to this Britishers. Right? Now, with the Maratha, there was a treaty with the Portuguese that they will be allowed certain passage in the Maratha territory. It passed to the Britishers, right? Britishers also allowed it. Now, once it passed to the government of India, the independent government of India, they refused to allow it. Now, the question is that does that custom of allowing has become part of international law, and can India refuse it? Right? Can India refuse it? That was the question, right? Obviously, the Portuguese claimed that no, India cannot refuse it, right? But the court held otherwise and said that no, made it clear that the local or regional custom which derogates from general customary law becomes binding only on the state that supports it. Okay? So if India is a state and that do not support it, right? India do not want that custom to continue, then they can very well go against it. Okay? So if you are following a custom, there has to be an intention to follow the custom, right? So the Britishers were allowing this passage only out of commercial consideration. So the court held that the custom was not created. So Nari is a very famous case. It is also called right of passage case. Right, right of passage. Name right of passage itself. Okay. No, no, I will not have the debate on Irgaon. It's not required at all. Okay, not required at all. Okay. Now let us come to previous year questions. Some of the questions. It is very simple, straightforward questions. Right? So no need to be super going to that. Okay. Now, see, if you look at the previous year papers, very simple. Today there is a huge shift on the basis of international law. Though principal component of international law is represented by binding rules of imposing duties and conferring rights upon the state, comment critical. Huge shift on the basis of international. So what is the shift it is talking about? So initially it was based on custom. Right? Nowadays this is most and most, the thing have been made into treaty. Right? So that is the shift actually it is talking about. Now, whenever you have a treaty, it is like a statute. It means it have some rights, it will have some duties. Okay, so that is the crux of the question. You have to compare and contrast that how initially it was mainly based on custom, right? And with the increasing, economic integration and other integration, right, it has led to more and more coming up of new treaties. So, clear, understood? Okay, so that is the shift actually it is talking about. Okay, now second, international law is defined as vanishing point. I have already discussed jurisprudency. This was the question that was repeated this year, 2017 also, 2014 also, 2013 also. Okay? So almost for last 10 years, almost 5 times this question has been repeated. Then it is merely a positive morality. Again, देखिए ये 3 क्वेश्चन है, पॉजिटिव मोरालिटी, वीक लॉ एंड वैनिशिंग पॉइंट. ये तीनों हर एक साल रिपीट होते हैं. एक साल ये आएगा, अगले साल ऊपर, अगले साल. ठीक है ना? सो यू हैव टू मेक अ फिक्स्ड आंसर फॉर दीज क्वेश्चंस. ठीक है, अंडरस्टूड. जैसे वो मैं जो राइटिंग प्रैक्टिस बैच जो मैं ले रहा हूँ, मतलब दूंगा, एक से स्टार्ट कर रहा हूँ, इसीलिए उसमें भी टाइम चला जाएगा एक्चुअली में. ठीक है ना? राइटिंग प्रैक्टिस बैच में मैं 5 क्वेश्चन दूंगा, बच्चों को एक्सप्लेन करूंगा ऐसे जूम पे, राइट? तो उसकी कॉपी चेक करूंगा. दैट इज वेरी टीडियस टास्क. तो यहाँ पे थोड़ा सा टाइम रिड्यूस करना होगा, राइट? तो बड़ा मुश्किल हो गया. Okay, right. So this question, remember, now discuss the importance of international custom as a source of international. Now think about it. This part तो मैंने बता दिया, uses crystallizes into custom, but how this international custom have what importance actually? See, custom has basically 3 importance. First, it introduces flexibility in international. Custom कोई fixed तो होता नहीं है, right? So some flexibility might be there. Second, the custom is a natural law, meaning that custom originates from the consent of the state, right? It means if the state wants that particular set of behavior that I am doing, I am expecting from you as well, right? It means that it is sort of a negotiating between two countries. That okay, I will behave like this, you please behave like this, right? So in fact, if you have read Roscoe Pound, he have also told that custom is basically the best law. Why? Because it is formed not by a politically superior or politically sovereign, but by the people naturally. right? So custom is also natural, right? So the same argument can be applied in international. That custom is the most comfortable law which a state can bind themselves to. Okay, so that is the second importance, right? It means the custom will lead to less and less, problem in case of conflict. Why? Because 100 साल से custom चल रहा है, there might have been problems, so the custom have adjusted or taken into consideration those problems. Okay, so that is the second benefit of custom, right? The third benefit of custom that it helps in determining provisions of treaty. अगर आपको treaty लिखना है, if you have to write certain treaty, then out of blue you cannot make the provision. You simply see the custom. Okay, these are my behavior. I will write that. Okay, so you can see that there are three basic, common sense. Basically, I must add common sense importance of custom with respect to international. So clear, right? So that is the first part of the question, and the second part of the question is how this crystallizes into custom. Uses crystallizes into custom, right? I know juris is one of the basic elements of not contental self case. Okay. Now let us come to question number 5. Now question number 5 says, now this question number 4 also you have to write, right? मैंने पहले बता दिया आपको, this question number 4 you have to write. पिछले बार का क्वेश्चन किसी ने सबमिट नहीं किया है, सपोज आंसर आई थिंक नो वन हैव सबमिटेड. What third is repeat? अच्छा, third, it helps in formation of treaty. It helps in the formation of treaty. Opinio juris है, not juris, ठीक है? Opinio juris. Okay. Doctrine of opposability you can study from anywhere. A lot of books, right? A lot of books. नहीं तो Google Baba is already there, right? It's always there, I suppose. It is always there. Okay, then the term general principle of law recognized by civilized nation is very wide and vague. Comment in the context of Article 38(1)(c) that I have already discussed, right? I talked about the meaning of general principle, right? So what do you mean by general principles? So general principles are those judicial principles which are recognized by the municipal courts. Okay, that is the general principle. I give the example, res judicata, the example I gave you, so that it can be a general principle. Similarly, equity and good conscience, that is also a general principle. Okay, apartheid has become a general principle, right? Okay, so those sort of general principles. Then, or like this pirates, enemy pirates, right? Pirate is a enemy of humankind, mankind, right? So that is again a general principle recognized by everyone. Okay, so that is the meaning of general principle. Then highlight the importance of judicial decision. Now, judicial decision, what does it do? Basically, it brings clarity, right? Second, acts as a precedent, right? And third, write it down, brings clarity. I should also write it down. Brings clarity. Second, acts as a judicial precedent. And definitional, remove definitional or textual infirmities. ठीक है, तो तीन देखा जाए तो significance है judicial decisions का international law. ठीक है ना, today I have not taken any copy, right? Because no one, I think one guy had submitted, Durgesh, I suppose, with Durgesh, right? But he's already, I think, a student of that, writing practice batch. So I will be checking and giving him feedback otherwise, okay? So I'm not checked any copy, right? So if you write any copy, write down. If you don't write, okay, that's all right. Okay, now I will invite questions. If you have any question, do ask. This is the fourth question that I have told you to write that down. If you have time, right, you can write the question number 4. Okay, now I will ask. If you have any question, do ask me your questions. Go ahead. Yes. Yes, Bandari Shrabya, please go ahead. I have unmuted you. Can you hear me, Ms. Bandari? Oh, so itself is gone. Okay. So I don't think anyone has. Oh, yes, Bandari, do you have any question? Treaties versus custom in India? The treaty will prevail. Okay. I don't think you have any question. Yes.
Hello, sir.
Yes, go ahead.
सर जो आपने लास्ट क्लास में क्वेश्चन दिया था
आवाज नहीं आ रही आपकी, स्पीक लाउडली।
सर लास्ट क्लास में जो आपने कॉन्स्टिट्यूशनल लॉ का क्वेश्चन दिया था दैट कॉन्स्टिट्यूशनल लॉ म्यूचुअली
Delegation of
सब्सक्राइब्स
power.
टू सॉरी सर
I have given the question of delegation of power, not the constitution.
sir one question you gave that the constitutional merely subscribes to the threefold division of gubernatorial functions and not to the doctrine of separation of powers in its absolute rigidity. So could you please explain this, the context of this question, because I was unable to, since you gave this answer, since you gave this question for answer writing in the last class.
So have you not attended the next class? When I give a particular question in the next class, when I check the copy, I describe that particular question. Okay. Now this particular question was basically related to administrative law, meaning that our Constitution of India says that okay, there are threefold division of power, but still the administrative law in India exists. Why? Because administrative law assumes that the executive is performing some of the function of judiciary. Now, if you
Okay.
perform some of the function of judiciary, then it means that clear-cut division is not there. So even if we have three organs of government, we have not a clear-cut division. It means that the Constitution of India do not recognize the division of power concept in absolute rigidity. That was the essence of the question. That you have to contrast that the development of administrative law has to do with the concept related to division of power. If the division of power is absolute, then the administrative law need would not arise. Right? So if the administration or the executive is doing some of the function of judiciary, then there is a need to balance that particular function because they are not designed for it. Okay? So that was
Okay.
actually the crux of the question. You have to compare and contrast.
Okay, sir. Thank you, sir.
Thank you. चलिए आकांक्षा fourth question we have to write the concept. Yes, opinio juris concept will come in the second part of that. Okay. Yes, so remember the next class will be on Thursday. Okay, so Wednesday, sorry, Tuesday and Thursday, 2 days I will be taking class. Okay, Tuesday and Thursday. I have written in the beginning itself, right? Tuesday and Thursday. Okay, I've told you why I have done it, right? Because a lot of batches are starting and it is really creating a problem. Okay, so that will be all for today. Thank you very much. Thank you. I told you Tuesday and Thursday, so how come the class will be there tomorrow? Very simple thing. Chaliye, so that will be all for today. Thank you.